We'll call the first item up, item number 1, ADM file number 2002-37. We have 3 endorsed speakers. I'll start with Livingston County Prosecutor William Valancourt. For purposes, everybody gets 3 minutes, but I know a lot of you have traveled quite a way, so we're not going to cut you off exactly at 3 minutes, but please don't abuse the privilege of extending it on.
Don't worry, I'm familiar with the rules. Good morning. William Valancourt, I'm Livingston County Prosecutor. I'm also the Vice President of the Prosecuting Attorneys Association of Michigan. Appreciate the opportunity to appear today. Prosecutors are certainly supportive of statewide e-filing. We found it to be especially efficient and useful in the appellate courts, and we especially appreciate its recent extension to the Michigan Supreme Court. But the amendments under consideration, calling for the identification and disclosures of cases involving a family member or dependent of a defendant in a criminal case, they're not only unworkable, but they're impossible for prosecutors to comply with. Pam's written comment, I think, aptly summarizes our opposition to those requirements and the difficulties they present. There's no need really for me to repeat them here, but I'd like to point out that the Michigan District Court Judges Association and the State Bar of Michigan have raised similar objections on these points. And I'd also like to specifically acknowledge and join in the observations of the State Bar Criminal Jurisprudence and Practice Committee. One option to consider, depending on how significant this information actually is to e-filing, is a modification of the bond rule to require their court to inquire of the defendant at arraignment of this information, because the defendant obviously would be the person in the best position to have the knowledge about their dependents and whether or not there may be any cases involving them. Similar procedures could also be established for respondents in juvenile cases or abuse neglect proceedings as necessary. I'd like to thank the court for their consideration, and we especially appreciate your action in suspending the implementation of these court rules while the court considers this. And I'd invite any questions.
This information is not part of what you do now?
No. I mean, we don't have any information as to a defendant's family background, whether they're married, whether they have children. Obviously, in the course of a police investigation, the focus is on other information rather than getting that. And so it's not information the police would ever obtain. It's not information we would ever have at our fingertips, being able to identify, spouse, people they've had children with, the identity of their children, and then trying to identify, are there any court cases, not only in our particular jurisdiction, but any jurisdiction throughout the state. And then the way the rule is worded requires not only to identify the cases, but to know what the impact is on what any court orders might have been entered. So theoretically, the duty that's imposed by this rule is to find those cases and then review the pleadings to see if there's any court orders affecting any family member or dependent of the defendant. We just don't have that information, and frankly, we don't have the resources to be able to do that either.
Well, that was well timed. Any other questions? Okay, thank you very much.
Well, thank you.
Have a good day.
Next speaker is Novi District Court Judge Travis Reeds, representing the Michigan District Judges Association. Good morning.
I may please the court, Travis Reeds, on behalf of the District Judges Association. I too appreciate this opportunity to be here and speak on behalf of our organization. I won't take all of my time because our commentary is fairly short. It's more of a nuts and bolts question that we have. The immediacy of the rule versus the practical application, especially in the district court, is what our concern is. E-filing is going to require modifications to hardware, to systems, and making it immediately effective is going to be problematic. But philosophically, we're definitely on board with e-filing. I think that's the way our world has been heading for a long time, and the court systems as well, and we're definitely supportive of that concept. Just the rollout, if you will, of that procedure is our only concern. And so that's all I had, unless there are questions.
Any questions?
No? I'm the serial commentator, if I didn't say that. I'm going to speak on it.
Yeah, we're going to see you a lot today, which is great.
All right, thank you very much. Our final speaker on item 1 is Lorraine Brown, State Bar of Michigan Access to Justice Policy Committee. Did I pronounce your first name correctly?
Yes, Your Honor.
Thank you.
Yes. Good morning, Your Honor.
Good morning.
My name is Lori Brown, and I'm the co-chair with the State Bar Access to Justice Committee. I'm also an attorney with the Michigan Poverty Law Program. I'm here on behalf of the Access to Justice Committee with the State Bar. The State Bar I'd first like to say the State Bar thanks this court for its continued efforts to implement a statewide e-filing system, and appreciate the opportunity that the court has welcomed feedback on this process. The statewide e-filing system has the potential to dramatically improve access to the courts for vulnerable populations. Given that, and wanted to make sure that this happens, the Access to Justice Committee set out several recommendations in its position statement to ensure that indigent representatives, the self-represented, the disabled, all will have access to the courts. I will just highlight at least 3 of the recommendations in our statement to ensure those access. The first one is the expanding the good cause exception to the proposed e-filing court rules. Currently, under the proposed rules, all litigants must e-file unless they have the good, satisfied good cause exception. The rules don't sort of sufficiently define the factors that will go into a good cause exception, and so we wanted to make sure that it specifically sets out factors that will ensure that this vulnerable population that we're talking about get to an opportunity to opt out. So factors such as whether they have access to an electronic device, whether they have access to a public computer, lack of transportation. Oftentimes we have clients who live in rural, don't have transportation to the public library to have access to the public computer. Also, if they have inability to travel as well. So certain factors. I mean, I had a client last year that I was going to her home all the time because she was disabled, a senior, and she didn't have ability to travel. And so a client like that would be a perfect client to be able to opt out, having to meet the good cause exception to opt out of the e-filing rules. Another concern is that we wanted to make sure that if we're moving towards mandatory e-filing system, the rules also require courts to help ensure accessibility by providing computer terminals at the courthouses and accommodating individuals who don't have access to emails, and also accepting payments other than credit cards. We have indigent litigants who have limited accessibility to credit. Also, there are the unbanked, and those have debit cards or credit cards. And so we're asking that there are alternatives such as being able to pay cash or a credit card, or a money order at the counter, so that to ensure that they have access to the e-filing process. And then, so my time is up. I just wanted.
You can sum up if you like.
Yes, please. Thanks. Okay. The State Bar also feels that there's fundamental access to courts to all, and the e-filing process will address that. All of our details information are in Access to Justice statement, and we hope that you take those into consideration.
Thank you. Any questions?
I just want to say thank you for being here. Obviously, with respect to e-filing, the idea is to increase access to justice, and I think it does that in many, many ways, but we have to be mindful not to leave folks behind, and so I appreciate your input in the process.
Yes, so thank you. Thank you.
Thank you.